The UK remains party to a number of international treaties and agreements protecting and enforcing intellectual property rights independently from membership of the European Union. UK membership of these agreements has not been affected, and intellectual property rights underpinned by these agreements remain protected. However, there are new arrangements for businesses working with intellectual property between the UK and the EU, and so you need to take action now. I will provide an overview of the key IP rights before looking at each in more detail. Exhaustion of IP rights. The key message is that nothing changes initially from the perspective of parallel imports from the EEA into the UK of IP protected products. However, you may face changes if your business parallel exports IP protected products from the UK to EEA countries. Trademarks and registered designs. All intellectual property rights in all existing registered EU trademarks known as EUTM and registered community designs known as RCD continue to be protected and enforceable in the UK. This has been done through the automatic creation of an equivalent UK trademark or registered design. So if your business has an existing trademark, it is now in the UK registry and you will not need to take any further action on this. And EU rights continue to be valid in the EU 27. Unregistered community designs or UCDs. Designs disclosed after the UK's exit are still protected under the current terms of the UCD through a new UK supplementary unregistered design right. Copyright. The international treaties to which the EU and UK are party mean that the vast majority of UK and EU copyright works continue to receive reciprocal protection. There are, however, some specific cross-border copyright mechanisms between the UK and the EU which have changed their current form. Patents. Leaving the EU has not affected the European patent system. This is governed by the non-EU European Patent Convention. Address for service. The address you use to correspond with the UK Intellectual Property Office and for proceedings under IP legislation needs to be an address in the UK, Gibraltar, or the Channel Islands. This section will provide you with information on the exhaustion of intellectual property rights. So to start, here is some detail on exhaustion of IP rights and parallel trade. The underlying principle is that the applicable IP framework allows rights holders the exclusive right to control distribution of an IP protected product. The exhaustion of IP rights refers to the loss of the right to control the distribution and resale of a product once it's been placed on the market in a specific territory, either by or with the permission of the rights holder. The UK is currently part of a regional EEA exhaustion regime. Once an IP protected product has been legitimately placed on the market anywhere in these EEA countries, the rights holder loses the right to control the further sale of that product within the EEA. Basically, from an IP perspective, it facilitates the free movement of goods within the EEA. This will remain exactly the same for imports into the UK, but as we are no longer part of a reciprocal regime with the EEA, the parallel export situation has changed. It is worth exploring these parallel export changes a little further. The headline is that for IP protected goods, the owner of the IP right in question will be able to prevent the parallel export of that goods from the UK to another EEA country. So the recommended steps are set out here. First, businesses should identify whether they currently parallel export IP protected goods to any EEA country. Second, if you want to continue to export these products, you should contact the owner of the IP to obtain permission to do so, bearing in mind that the right holder may choose to withhold permission. Third, you may need to review your business model and position. You may need to seek legal advice if you require further clarification. If in doubt, businesses that own IP rights may wish to seek legal advice if their IP protected goods are parallel exported from the UK to the EEA. Please note, parallel imports from the EEA to the UK are unaffected. The final important thing to say on exhaustion is that government will be conducting a consultation to determine an appropriate future exhaustion regime for the UK. We will be consulting in the first quarter of 2021, so please keep up to date and let us know what you think. Use the QR code or search for Exhaustion of IP Rights and Parallel Trade from the 1st of January 2021 on gov.uk for further information on actions that parallel exporters to the EEA and intellectual property rights holders will need to take. This section will provide you with information and actions that you need to take if you currently hold EU trademarks and registered community designs, otherwise known as design rights. The key message here is that EUTM and RCD holders will get a comparable registered and enforceable right here in the UK. This means we're adding around 1.4 million trademarks and 700,000 designs to the UK registers. This will happen automatically. There are no forms, no fees, and no admin procedure required. The filing and priority dates are preserved. You won't receive a certificate for these new rights, but you can take a screen print from the website as evidence of your right if you need to do so. Term and first renewal date are to remain the same as for the old right. If your renewal is due in the first 6 months of 2021, you have additional time to pay to renew your UK comparable right without incurring late renewal fees. Invalidation or revocation proceedings that are ongoing against an EU right will lead to invalidation revocation of the comparable UK right if the EU right is invalidated or revoked. But the rights holder can argue at the IPO that the invalidation revocation should not apply to the comparable right on the basis that the grounds are only applicable in the European Union. For pending EU applications, there will be a window until the 30th of September 2021 to file your equivalent UK application and preserve your filing and priority dates. Holders of international trademarks and designs designating the EU will now have an equivalent UK trademark or design. This is automatic and free, with no re-examination or admin procedure. Filing and priority dates are preserved. Also, UK seniority for trademarks. This is comparable to UK-TN, UK-008, plus existing EU IR numbers, UK-RD, UK-8, plus existing EU IR number. In summary, the IPO has automatically created a UK right for every registered EU trademark and design, and every international trademark and design designating the EU. This means that you need to renew your UK rights separately at the UK IPO. Your EU Intellectual Property Office, EU IPO, rights continue to be valid and renewable through the EU IPO. They continue to provide protection in the EU. Use the QR codes or search on gov.uk for more information on trademarks and design rights. Current holders of unregistered community designs can continue to enforce their rights in the UK as continuing unregistered designs. The terms and conditions for protection in the UK are identical to the corresponding EU right. The right continues to exist in the EU. For disclosure, there is now a new UK right called the Supplementary Unregistered Design. This mirrors the characteristic of the unregistered community design and is triggered by first disclosure in the UK. There are no UK residency or business requirements. So what do you need to be aware of with unregistered design protection? Well, you may want to consider where you first disclose your design, as there will no longer be reciprocal recognition between the UK and EU member states. In other words, disclosing first in the EU will not establish a UK supplementary unregistered design. It may destroy the novelty in that design should you later seek to claim UK unregistered rights. The same applies in reverse. If you disclose first in the UK, the advice is you should carefully consider how, when, and where you first disclose your designs in order to establish unregistered protection in the most important territory to you. Use the QR code or search for changes to unregistered designs from the 1st of January 2021 on gov.uk for further guidance. This section will provide you with information and actions in relation to copyright law. Copyright law is largely harmonised internationally by a series of multilateral treaties to which the UK, the EU and most other countries are party. Our membership of these treaties does not depend on our relationship with the European Union. This ensures the majority of copyright works continues to receive protection around the world. As a result of the statutory instruments implemented under the Withdrawal Act, UK copyright legislation will continue to function as it did previously. This will maintain high levels of copyright protection for most businesses and creators. However, there are a small number of cross-border copyright mechanisms that are unique to the EU, which have either ceased or can't function on a purely domestic basis. These are sui generis database rights, country of origin copyright clearance for satellite broadcasts, cross-border portability of online content, and online use of orphan works for cultural heritage institutions. If you have concerns regarding these issues, use the QR code or search for changes to copyright law from the 1st of January 2021 on gov.uk for further guidance. For businesses who may be impacted by the changes to cross-border copyright mechanisms, we encourage you to check their existing business arrangements and/or contracts if they have not already done so. Unfortunately, the IPO is not able to provide bespoke legal advice on contractual matters, so you may choose to seek legal advice and guidance for your business needs. Looking at the impact on the cross-border mechanisms in more detail. Sui generis database rights. This is a unique EU feature that protects investment in obtaining and verifying databases. Sui generis protection of UK databases continue on a domestic basis only. UK databases published prior to the end of the transition period continue to be recognised in the EU and vice versa. There is no mutual recognition for sui generis databases published since the 1st of January 2021. Country of origin copyright clearance for satellite broadcasts. Previously, satellite broadcasters transmitting films and other copyright protected works across the EU needed permission from the copyright owner only for the state in which a broadcast originates, rather than in every state in which it is received. The UK continues to recognise this principle for EU and other third countries. The approach taken by EU member states will vary depending on how their domestic laws treat satellite broadcasts from third countries. We therefore advise satellite broadcasters to seek legal advice where they broadcast into the EU. Cross-border portability of online content. The legal obligation to provide temporary portability of online services into the EU has ceased under our withdrawal legislation. Providers of these services should still be able to continue to provide these services if they so wish, though they may need to revise licensing agreements in order to do so. Orphan works. UK cultural heritage institutions won't be able to register orphan works, which are creative works or performances protected by copyright, where one or more right holders are unknown or cannot be found. These will not be able to register on the EU database, and the EU member states will cease to recognise the orphan status of UK works. Currently, putting orphan works online and accessible to EU-based users could potentially run the risk of an infringement. Distinctly from the EU exception, the UK operates its own domestic licensing scheme for orphan works, which continues and can be used for any orphan work, regardless of where the work originated. If you are affected by any of the copyright issues I've highlighted, do check the information available on gov.uk. We would also advise you to seek further legal advice so that you can comply with the new changes currently in place. This section will provide you with information and actions that relate to patents and patent law. The majority of UK patent law is set by the European Patent Convention, known as EPC, which is entirely independent of EU law and so has not changed. EU law does provide additional patent protection for pharmaceutical products and agrochemicals via supplementary protection certificates, known as SPCs. Although this is EU law, SPCs are applied for and granted at a national level. The extra period of protection provided by SPCs compensates for the often lengthy approval process before patented pharmaceuticals and agrochemicals may be sold. The UK has retained EU legislation on supplementary protection certificates, and so the UK's SPC regime continues based on the retained EU law. Existing UK SPCs granted in the UK under the current system continue to be valid. Rights holders continue to be able to apply for SPC protection in the UK for patented pharmaceutical and plant products. Existing SPCs in the EU27 held by UK rights holders are unaffected, and UK rights holders are able to apply for new SPCs in the EU27 under the current system. SPCs may be granted when a patented drug or agrochemical receives a marketing authorization to sell the product, but since the Northern Ireland Protocol has come into effect, there may be two such authorizations for the same drug or agrochemical in force in the UK, one for Great Britain and one granted under EU law for Northern Ireland. Some changes to the SPC system have been made to accommodate this. Applicants will still be granted an SPC for the UK if they meet the requirements, but this only provides protection where there is a valid authorization UK-wide in Great Britain or in Northern Ireland. Detailed guidance for businesses to help them use the SPC system is now provided by the IPO on its website. An address for service is an address that you use to correspond with the UK Intellectual Property Office, known as the IPO. You also use this for the purpose of proceedings under IP legislation. It can be your address, or if you wish, you can provide the address of your attorney or representative. You now need an address in the UK, Gibraltar, or the Channel Islands before the IPO consider your application. This means we will no longer accept addresses in the EEA. We continue to accept the Isle of Man as a valid address for the service. We are not changing the way we process any of our forms or changing any procedures. And please note that if your business has filed for an application before the 1st of January 2021, then you can continue with your existing address for service. For more information, please consult our business guidance on gov.uk. Lastly, use the QR code or search for intellectual property after the 1st of January 2021 on gov.uk for key information for customers and users of IP about how the IP system and the Intellectual Property Office will operate after the end of the transition period. New rules are here. Our preparation can take longer than you think. You need to take action now to keep your business moving.